Good afternoon, everybody, and welcome to this webinar dedicated to the new securitization law in Luxembourg and organized by the Luxembourg Capital Market Association, the 𝗟𝘂𝗃𝗲𝗄, and its members. I'm Smaïn Bouchareb, CRD at IQEQ Luxembourg, dealing with institutional clients and leading the capital markets development. I have the great pleasure of being the moderator for this event today. The 𝗟𝘂𝗃𝗲𝗄 represents the common interest of all stakeholders of the primary capital market industry of Luxembourg. It was set up in the 1st March 2019 in order to promote the Luxembourg capital markets. It has also as mission to provide networking, collaboration opportunities, sharing of experience, and encouraging innovation in this industry. It also aims of being the single point of contact for authorities, association, market practitioner, and any other actor of the Luxembourg capital markets. Today, the association counts 44 members as the Luxembourg Stock Exchange, several law firms, banks, audit firms, and in general professionals of the financial sector as, for example, corporate services provider. For the topic of today, it is about the long-awaited modernization of the Luxembourg Securitisation Law that was released back in 22 March 2004. A project of modification was submitted to the Chamber of the Députés on the 21 May 2021. And the aim is to continue to build the successful story of the securitization law in Luxembourg and to clarify its framework, to adapt it to the new requirement of the market and provide further flexibility. So today we are launching a series of 2 webinars in order to comment on this new bill, and in particular in focusing on 9 main changes. So the first webinar, the one of today, is dealing with the legal framework and the practical aspects of this draft law. The second webinar will be more dedicated to structuring aspects. For the topics of the day, we decided to go for 6 main changes: financing, legal form, flexibility on granting security interest, public issuance and CSSF role of supervision, compartment, securitization fund registration. 3 other topics will be tackled during the second webinar and will be related to the active management concept, the statutory subordination for different types of financial instruments in indirect acquisition of risk. The today webinar, as well as the next one, will be recorded and will be available on the 𝗟𝘂𝗃𝗲𝗄 website and its YouTube channel. Please feel free to use the Q&A function to drop questions, and the panelists will try to answer them at the end of this session. So, for today, we have the pleasure of having with us 3 panelists who are practitioner actors of the capital market landscape in Luxembourg, and who are also at the same time members of the Luxembourg Capital Market Association. So I have the pleasure to introduce you to Alexandra Fantuz, Serge, Zeien, and Andreas Heinzmann. So maybe a few words of introduction about yourself. Alexandra, please.
Yes, thank you. So my name is Alexandra Fantuz. I have been working in the financial industry for more than 15 years. I specialized in securitization and structured finance products. I joined Trustmoore 2 years ago, and Trustmoore is a corporate and fund administrator, fully licensed. We are based in Luxembourg, but also we have offices worldwide. And we have a boutique-style approach that is very much appreciated by our clients.
Thank you very much. Serge?
Hello, welcome all. My name is Serge Zeien. I'm a counsel at 𝗟𝗂𝗃𝗄𝗃 Luxembourg in the International Capital Markets Department. And I specialized in equity and debt capital markets, including securitization, so the topic of the day.
Thank you, Serge. Andreas?
Yeah, hello, good afternoon. My name is Andreas Heinzmann, and I'm a partner in the banking and capital markets group with the law firm GSK Stockmann.
Thank you. So maybe before to tackle the 6 main changes we have selected to discuss today, let's go for a quick introduction and get some context about the securitization law and the need of modernization. So for that purpose, I will hand out to Andreas, maybe, in view to give us a bit of historical aspect and to explain us why there will be a need of changes.
Yeah, thank you, Smaïn. I'm happy to do that. Welcome everyone to that LuxCMA webinar on the draft bill of the new securitization law. We thought before we go into the details of the changes, we take a step back and look a bit what happened so far between 2004 and now. I think the fact that, so to say, the definition of securitization did not very much change now in the draft bill shows the sound drafting of the mothers and fathers of the securitization law. I think the securitization law has been proven to be very resilient over the years. Also made Luxembourg to one of the major hubs and jurisdictions for securitization transactions in Europe. We have now around 1,400 vehicles, more or less. I do not count the compartments. We can do, via the law, regulated securitization vehicles and also unregulated securitization vehicles. We have a further flexibility with the possibility to establish also securitization funds. We can do true sale securitizations, we can do synthetic securitizations, and I think one main goal of the Luxembourg legislator has already been achieved, namely the investor protection via the introduction of provisions regarding compartments, contractual limited recourse, and also non-petition provisions. I think in 2004, the main topics were classical banking securitizations, such as true sale of receivables, but also structured finance transactions involving derivatives. All these transactions were mostly foreign law governed, and I think that has also changed over the years. In 2008, the securitization market was hit by the financial crisis, but securitizations were still used also with regard to restructurings. In 2012, the AFMD was introduced, and I think since then, securitizations are more widely used also for alternative structures. And then last but not least, in the aftermath of the financial crisis, the European Commission developed the wish to create a capital markets union in the EU and to revive the EU securitization markets. I think the adoption of the EU securitization regulation and also the statements of the EU Commission that functioning securitization markets are important with regard to diversification of funding and freeing up bank capital for investments is a good sign for the securitization industry and for Luxembourg as a first-class securitization jurisdiction. So last but not least, I think we can say the securitization law has proven to be a major piece of legislation for the financial sector in Luxembourg, and the draft bill aims to address certain changes to adapt the law to the most recent legal and market developments in Europe.
Thank you so much, Andreas. Now, in particular for those changes, so you explained a bit the genesis, but would be good to understand maybe a little bit more why and what next. So, Serge, maybe a bit of insight about this part?
Happy to do so. Yes, as Andreas already said, the Securitization Act has now been out since 2004 already. So there have been many changes in acts relating to that law, and also new legislation appeared in the meantime, like the EU Securitization Regulation, which called for an update of the Securitization Act. The draft bill is actually long awaited, as Andreas said, by the market. It was expected, we were expecting to see a modernization of the Luxembourg Securitization framework already nearly 2 years ago. And obviously the pandemic did not help also to speed these things up. Now the Luxembourg Ministry of Finance actually carefully listened to the markets and had a close look at what happened on the ground in terms of market practices in over 17 years when they were putting together the bill. So they made an effort to adapt the securitization regime to the market demand and expectations, which means that first of all, and Andreas already pointed it out, the well-known features such as the compartment structures, limited recourse provisions, ring fencing, the favorable tax treatment, etc. They are not meant to disappear. So that's very good news. The bill is really meant to be an upgrade as it will increase the flexibilities and possibilities in structuring securitization transactions. So, as you already said, there will be additional means of financing, new corporate forms for the securitization vehicles. Security interests and guarantees will be more broadly available, and active management of CDOs and CLOs will finally be possible. And this will be covered, as you said, over the 2 webinars.
Thank you so much, Serge, for this overview. And let's maybe go now and dive into the topics that we are suggesting to tackle today. So for the first part, let's go to the financing. So financing, securities issuance is no longer the rule. Any financial instrument is now eligible, including loans. So this is a broadening of the means of financing, so financial instrument, but also loans. And let's maybe discuss a bit about the financial instrument concept and what we call a titre, and see in which way, this has been for a long time seen as an ambiguity. So maybe Andreas, if you would like to shed some light on this concept.
Yeah, thank you, Smaïn. Happy to do so. I wouldn't call it an ambiguity, but indeed, let's say Luxembourg law is by nature very international. And I think we came across, so to say, various concepts of what is a transferable security or what is a financial instrument. Maybe let me start with the changes which have been made to Article 1 of the Securitization Law. Basically, the main change is that, so to say, the reference to the term valeur mobilière has been replaced by transferable security. Sorry, the reference to the term valeur mobilière has been replaced by instrument financier, which is a financial instrument. Obviously, the term transferable security is not as broad as financial instrument. So far, we didn't have in the securitization law a definition of what is a security. There are some references in Luxembourg law. We also have definitions with regard to, let's say, MiFID and also the prospectus law and now the prospectus regulation. And there are certainly some key elements which are important. But there were some, so to say, gray zones in particular where the securities were not governed by Luxembourg law, but rather by foreign law. And now, let's say, I will make an example a bit later. Now we have a, let's say, definition in the securitization law, what is a financial instrument, and that refers to the definition in the collateral law 2005, namely to Article 1.8 A to E, and there we have a very, very broad definition, which would also cover, for example, instruments which are not necessarily securities under their own law. One example to which is also referred in the comments, but also in the Q&A of the CSSF, is the German Schuldschein, which, as such, under German law, is not a transferable security because the transfer is not done by delivery, but by assignment. Nevertheless, securitization companies used that instrument in the past, and also the CSF was positive about that. But nevertheless, there was some uncertainty, and I think with regard to the introduction now of the term financial instrument, we have a much better view. Let's say what can be done in terms of issue and funding instrument by Luxembourgish securitization undertaking.
Thank you so much, Andreas. So a very welcomed clarification here. So now, what about the loans, the tranching, and the lifting of the limitation of granting of loans? So maybe Serge, you want to add some words about that?
Yes, happy to do so. Thank you. Well, you said the lifting of the prohibition. Actually, the prohibition as such was never contained in the securitization law that expressly contained that loan financing would be possible. The only thing we really had was the FAQs of the CSSF, which said that loan financing is possible in 3 limited circumstances that you know. So one, during a warehousing period where you basically take out the loan and then refinance it afterwards once you have built up your initial portfolio. Another one for liquidity shortages. So there you can do a facility, and thirdly, as a permanent loan, which however needs to be ancillary at all times, which means it cannot be bigger in volume than any securities issued. So, and that current framework proved to be problematic in many transactions. For example, some investors, for one reason or another, cannot invest into securities, or another example is that typically securities issuances are less cost efficient than a straightforward loan. I think they're on the situation where you only have a single investor, so it could be drafted much easier. It also appeared that the requirements to fall inside the scope of the securitization regulation, of the Securitization Act, are currently stricter than those of the EU securitization regulation in this respect, as the EU securitization regulation can also be triggered by securitization only financing by way of loans, which is not possible, as I said, under the Securitization Act right now. So under the new regime, it will be then possible to finance securitization vehicles exclusively by the way of loans. This will obviously make structuring securitization transactions much easier, and I also expect securitization vehicles being used where bank financing is required more often, for example, in the alternative investment fund sector. Back to you.
Thank you very much, Serge. So let's now go to our second part related to the legal form, and we have now more options with inclusion of partnership. So within the original securitization law, only 4 forms of corporates were possible, meaning the public limited company, so the Société Anonyme, the corporate partnership limited by shares, Société en commandite par action, the private limited liability company, Société à responsabilité, and the cooperative company. Now, with the introduction of this new bill, there is a suggestion to modify the law in the way to enlarge to other possibilities of corporate forms. So the new suggested forms are mainly the Société en nom collectif, General Corporate Partnership, Société en commandite simple, Simple Limited Partnership, Société en commandite spéciale, Special Limited Partnership, and Société par action simplifiée, Simplified Joint Stock Company. So clearly we are seeing here that in addition to the 4 existing forms allowed, there will be 4 more, including partnership. So what does this mean concretely? So from an era where only 4 opaque corporate structures were allowed, there will be an addition of tax-transparent corporate vehicles like SENC, the General Corporate Partnership, and the SCSP, the Special Limited Partnership. So before the introduction of this suggested modification, the only way to structure a securitization via a transparent structure was to set up a securitization fund and a ManCo. So the fact that there is now the suggestion to also be allowed to use partnerships and having it governed by the securitization law will not prevent the partnership from drafting and filing annual accounts with respect to the law of 2002 with respect to the Register of Commerce and financial statements. And as a good news, we are seeing as a good news this extension of range of corporate forms that will be available should attract investors like PE firms, family offices, which are already very familiar with the successful Luxembourg partnership regime. Let's go now to our third topic of the day, which is the flexibility on granting of security interest on the assets. And here, I would like to hand over to Andreas. So maybe if you could kindly explain us what is the current regime about security interest and its limitation, and how the new law is proposing to extend it. I guess you are on mute, Andreas.
Can you hear me now?
Yeah, perfectly.
Okay, thanks. With regard to, let's say, what we just heard, namely that we have, let's say, various new corporate forms which have been introduced, I think that reflects also, let's say, the need of the market for, let's say, for new funding vehicles. And I think at the inception of the securitization law in 2004, that was not necessarily the case. I think what was key at the time was the, so to say, the very high degree of investor protection, as already mentioned, driven by the fact that a securitization vehicle always acts as an agent for the investors and has in principle no equity. And therefore, it's clear in the current law that basically guarantees or security interest cannot be granted to any other party than the investors or the security agent or the trustee, which is acting on behalf of the investors, because the assets either allocated to the securitization vehicle or to a specific compartment of the securitization vehicle are exclusively available to satisfy the obligations of the investors or any other creditors. So that's the current state of play. But as already mentioned, I think over the years we have seen, in particular in the alternative space, that securitization vehicles are, for example, used as funding vehicles to fund a mezzanine tranche, for example, in a transaction. But that means typically we have also a senior lender, normally a bank, which is in the transaction, but the bank is not a transaction party to the securitization transaction. It is not a sponsor, it's not an investor. And therefore, under the current law, the granting of security interest would have been void. So I think the proposed change to open that up and to create more flexibility, I think that leads to let's say a further upgrade with regard to what you can do with the Luxembourgish securitization vehicle, and in which a transaction or project such a vehicle can be used.
Thank you so much, Andreas. Let's go to the next part. Public issuance and CSSF role of supervision. So here we would like to discuss about activities which are triggering a regulatory supervision, and maybe I will hand out to Serge if you may maybe remind to the attendees the difference between the regulated and the unregulated regime, also the inclusion of the FAQ of the CSSF, and maybe also some clarification about a couple of definitions like issuance to the public and so on.
Happy to do so, and I'm a bit conscious of timing. Maybe I make this a bit quicker than expected. So as you know, there are the two types of vehicles, regulated, unregulated one, and the criteria for a vehicle to fall under the CSF supervision are the fact to make public offers on a continuous basis. So the draft bill will not really change the regime, but it was the definitions were included, as you said, in the FAQs of the CSF until now, and they will be included in the law once in force. So that will obviously increase legal certainty in this respect. Under the new regime, there's a slight change in the definition of on a continuous basis, because it was always calculated on the calendar year, and now it will be calculated on the financial year of the vehicles. But as for most vehicles, calendar year and financial year are the same. This will really not impact many structures. For this, it is important to note that private placements will not be taken into account for this test. More important, on the other side, what is an offer to the public? The new regime provides for basically the same elements as the CSF FAQ, but there will be some slight changes. On the denomination of the financial instruments, we will go from 125,000 to 100,000. So this is to align the securitization regime with the wholesale exemption under the prospectus regulation. And all in all, the conclusion can be here that when you issue only to professional clients, you have still the best outcome. To have no CSF regulation, there will be no requirement for a prospectus regulation compliant prospectus, and no key information document under the PRIPS regulation. Hope that answers all your questions.
Thank you so much. Let's go now to the fifth part and talk about compartments. And the clarity on equity treatment. So compartment operation adjusted for equity financing, and maybe I will let Alexandra talk about this this part.
Yes, thank you, Smaïn. So to give a bit of background, there currently exists no specific guidance for the distribution of profits of equity finance compartments within a securitization vehicle, other than that provided by the Luxembourg law on control companies. This has historically presented issues for service provider like Trustmoore and for auditor, given that the specific nature of a securitization vehicle differs from that of a holding company for which the law was written. Specifically, the question of cross-contamination between compartments in a multi-compartment securitization vehicle has found extensive discussion in previous analysis. Furthermore, despite the accepted market practice, there is no definition of the required approval procedure for a distribution to be made with reference to the shareholders of an individual compartment. So now, the Article 11 of the draft bill amends the Article 47 of the Securitization Law by adding a new paragraph 2. And this new paragraph 2 addresses these concerns. In particular, the securitization law is expected to stipulate the ability of the individual compartment shareholders to determine and approve the level of distributions of that specific compartment in a compartment shareholders resolution. This should be done without reference to the overall shareholders of the vehicle and regardless the global situation of the securitization. Such a distribution will be contingent on the existence of a specific legal reserve of the compartment. This should be clearly set forth in the constitution documents of the securitization vehicle. So, in practice, the constitution documents of the securitization vehicle should determine 1. The shareholder votes on annual accounts of equity finance compartments, 2. The creation of a legal reserve of the compartment, and 3. The distribution of profits at the level of the compartment. As just said, the individual compartment shareholders will have to create and feed a legal reserve before dividend can be distributed. It means that profit-making compartments financed by equity instruments, in other words, disclosing subscribed capital, must make an allocation to a legal reserve of that compartment on an annual basis. So just for memory, the legal reserve amounts to 5% of the net profit until 10% of the subscribed capital is reached. It goes without saying that available sufficient retained earnings and cash reserve at the level of the compartment, rather than the whole vehicle, are required where such distribution is cash settled. It will be useful for the investor awareness that the constitution documents clearly stipulate such mechanisms, as well as the timing for the approval process, in order to avoid any delay with the compulsory filing and publication of the annual accounts of the securitization vehicle as a whole. As for existing securitization vehicle at the time of the entry into force of the amended law, well, I would say that they may need to amend their articles of association accordingly. In summary, these clarifications provide legal certainty as to the accounting regime and the dividend distribution procedure for compartments financed through equity instruments. They confirm the principle of treatment of each compartment as a separate entity. Investors should become actively involved in the decision-making process relating to dividend distribution. Furthermore, all securitization companies, including Société en commandite simple and Société en commandite spéciale, as already mentioned by Smaïn earlier, will be required to prepare their annual accounts based on the same accounting principle. We believe at Trustmoore that the legal certainty and the consistency in the accounting regime and related transparency provided by the expected law have the potential to increase interest in the use of equity finance securitization transactions. Perhaps, as mentioned earlier by Smaïn, within the field of private equity and multifamily office investors, but also perhaps with asset managers dealing with real estate debt. This is a question that I keep for the next webinar next week.
Thank you so much, Alexandra. So maybe I will keep you for the last part. So the sixth part is related to another practical aspect. So the securitization funds that will need to be registered with the Registre du Commerce et de Société de Luxembourg.
Yes, thank you, my pleasure. So the vast majority of securitization vehicles are established in the form of a company. As for securitization funds, they have seen a continued rise in recent years and notably during 2019. Currently, as you said, securitization funds are not required to register with the Luxembourg Trade and Companies Register, and they are not issued with a registration number. This has historically presented complications with certain administrative formalities, for example, requesting a stock exchange listing. The Article 5 of the draft law amends the Article 10, paragraph 3 of the securitization law so that securitization funds are required to register with the Luxembourg Trade and Companies Register. In practice, the management company must file the management regulations with the Trade and Companies Register and publish the same in the recueil électronique des sociétés et associations. The same procedure applies for their liquidation. The bill further introduces a new point in the Article 1 of the law of 2002 regarding the Trade and Companies Register to clarify that the registration of the securitization funds must be made in the same format as used for FCP, Fonds commun de placement. Securitization funds already in existence the day the new law will come into force will have 6 months to comply with the provision of the new Article 10.3. As a general reminder, all entities registered with the Trade and Companies Register must file the details of their beneficial owners with the Beneficial Owners Register. The objective of this change is to provide securitization funds with a clear publication regime and the issuance of a registration number. In addition, it provides investors with an additional means in identifying a securitization fund, which will be very useful from a marketing perspective in public offerings. As discussed previously, société en commandite simple et société en commandite spéciale may be considered as an alternative to the use of a securitization fund. This may be perhaps something that our colleagues will talk about in the next webinar.
Maybe. Thank you so much, Alexandra. We have covered now the 6 main changes we wanted to talk about. And let's go now for a Q&A session. We are running a bit out of time, so we will try to answer as much question as possible. Otherwise, the remaining ones, we hope that we will be able to answer them in written or even maybe during the second webinar. So one of the first questions was related to the date or the timing as when the new law will be enacted.
Maybe I can take that one. Well, I think I would expect to be entry to force to come later this year, end of this year, but please don't quote me on that.
Yeah. So there is a second question that is also related to the adoption of the law, and can it be still modified in the meantime? So maybe I will take this one. Yes, there are already some suggestions or some comments that will be provided. For example, the Luxembourg was invited by the Chambre de Commerce to provide its view and to provide some comments, suggestion of amendments. Then another question, could you please explain a typical figure where a securitization would grant loan to acquire underlying assets or risks?
Well, I think I can answer that briefly. I mean, we have already in the CSF Q&A nowadays the possibility that a securitization company can provide loans. So I think that's a fairly standard structure. So the assets which can be financed obviously can vary, and the loan is funded by the issue of securities. And once the law is adopted, in theory, the loan financing provided by the securitization vehicle could also be financed via a loan, which would be granted to the securitization vehicle.
Thank you, Andreas. Another question that is also about nearly the same topic as this one. How a securitization vehicle authorized, so I assume here we are talking about a supervised vehicle by the CSSF or a regulated one, would issue financial contract to financing the acquisition of the underlying assets. Any volunteer?
I have some difficulties understanding that one, I must admit.
Maybe the question is whether a regulated securitization undertaking can also fund itself via the issue of a loan. And given the changes, at least as proposed in the draft bill, I would say yes. But indeed, I think we all need to get used to the idea that a securitization vehicle will entirely be financed by loans. But I think we need to see what is the outcome of the legislative process. But on the basis of the draft bill, I think that that would be feasible.
I would also agree to that.
Sorry, Serge?
I would also agree to that, of course, if we need to get used to seeing more and more loans, even for regulated ones.
Thank you so much to you for your valuable inputs for today's webinar. I hope that the attendees learned some useful thing about this draft new law. As we said already, this law is still not enacted. There are still some comments that will be discussed about it. And in the coming month, we hope that we will have even more clarity on the final text. And we also would like to remind you to already save the date for the second webinar, also dedicated to this new Luxembourg Securitisation Law, where our panelist and moderator will talk about the structuring aspects of this new bill. So please save the date on Friday, the 2 July 2021. And a special thanks to the 𝗟𝘂𝗅𝗖𝗍 team, to all the members of the 𝗟𝘂𝗅𝗖𝗍, as well as the Luxembourg Stock Exchange for their help and their support for this, I hope, nice event. So thank you very much again. Good afternoon. Have a nice weekend ahead. Goodbye.